All right, well, with that, we will start with NMB Enterprises versus Winona English. So if you want to come on up here. And Mr. Johnson, did you want to, or excuse me, Mr. Vaughn, did you want to reserve any time for rebuttal?
Yes, Your Honor, I would request 5 minutes.
5 minutes, okay. Whenever you are ready.
Your Honors, this matter came before the appellate court last year. This case was remanded with express instructions to the district court with how they wanted to approach this matter. Specifically, this court ordered the district court to determine NNB's cost for production and marketing of gas produced on the lease using the method that most accurately reflects its actual costs. It followed up by saying that the district court is not bound by either proration method, the methods being per MCF, so production, or per lease or well. On remand, the district court was also ordered to determine the direct cost for operating the lease using the method that best fits the attributes of each expense. We argue, Your Honor, respectfully, that the district court failed to adhere to this court's orders on remand when they gave the district court discretion to say, or to determine whether it should be on a per MCF basis or on a per lease or well basis. And so the question is an issue of law, which would be a de novo standard of review. In the district court's order on remand, the court at first addressed, there's four expenses. The first one is chemicals. And by agreement of the parties, the chemicals were conceded to that they should be on a
Per volume.
per volume basis. Thank you. And then on the compressor issue, we conceded that it should be on a per lease method. So those two expenses are not at issue anymore. The third and fourth expenses, specifically contract labor and repairs and maintenance, those were addressed. The district court in its ruling simply stated that the Court of Appeals clearly rejected NNB's justification that the costs resulting from per lease proration method are much higher than its cost would be if operated the lease independently by tracing its exact costs. Same thing with maintenance and repairs. The district court simply said, once again, NNB essentially restates its arguments. The arguments were clearly rejected by the Kansas Court of Appeals. Respectfully to the district court, that's not what I believe to be the intent of this court. This court requested that the district court, the Honorable Judge Kreitz, make a fact finding based on those specific issues and make a ruling on how they should be appropriated. And the court rather seemed to imply that this court completely rejected those arguments and that they should be on a per lease basis. And so for those reasons, we believe that this matter should be remanded to the district court with specific instructions to make those findings based on.
Is it your position that the district judge didn't take the mandate to mean that he's to decide the most appropriate way to divide these up? He chose lease, or he chose the method he chose for, I'll get them mixed up if I say them, for the labor and the repairs and maintenance, and came to a conclusion. If there is substantial evidence to support his conclusions, isn't that enough?
I believe
we asked him to look at it and decide the best way. He decided the best way, even though it may seem like he was feeling his hands were tied with regards to one method. But he did make findings as to why he decided the way he decided, right?
That is correct.
Mm-hmm.
That is correct, Your Honor. This case has been going on for approximately 6 years.
Mm-hmm.
So to answer your question, the issue of contract labor was approximately 5 sentences. And the key sentence that I pull out of this is that the Court of Appeals clearly rejected that argument.
Mhm.
So I would assert that the district court felt that their hands were tied when they made their decision for contract labor, and the same for maintenance.
Didn't the district court though also say, because you pulled out just a couple of sentences, that the Court of Appeals remanded back saying no specific method was required and that he could pick a method, and then actually had you guys brief it again, right? And had all of that information. It's not, the district court didn't just take the remand and say, oh, the Court of Appeals said I had to do this. I mean, there's a bunch of other stuff. So isn't it possible to read this to just say that, you know, after looking at all of this, you haven't convinced him that it should be by volume?
That's possible, Your Honor, but I would argue that based on the facts of the case, the second issue that we briefed was on the specific issue of substantial competent evidence. When it comes to the contract labor.
Let me stop you for just a minute. Were you able to put in all the evidence you wanted to put in as to what the most appropriate method would be?
We provided briefs. We offered to present.
But you presented your argument, all your argument as to why it should be one method over the other for labor and then for repairs.
Correct.
And the other side presented their reason, right?
Yes.
So we have all the information before us today that the judge would have had. You frame this as an issue of, did the judge comply with the mandate? What is our position of just de novo reviewing that evidence and deciding?
Well, I think if you look at Judge.
We say he didn't do the mandate, but we've got all the same information here. We can decide.
Then at that point in time, I believe it would go to abuse of discretion because it would become an issue of fact and not law.
Uh-huh.
And I think that's the important distinction is.
So if it goes to an abuse of discretion standard, it's hard to win.
It is.
Under that criteria. So you're putting all your eggs in the mandate basket that the judge felt that it had to be on the per lease basis. Therefore, you want to go back and have yet another review as to, did he really mean that was the best way?
Yes. I think that his statements are completely at conflict with Your Honors in the initial ruling that this court made. The Court of Appeals cited several different options. They said maybe it would make more sense to have contract labor applied this way, and maybe it would make more sense to have this. But when you have the district court judge saying that those arguments were clearly rejected, I think that that's effectively tainted his position, and it's not an issue of the facts. It becomes an issue of what he perceives this court to have mandated that he do.
Well, what was the language in the mandate or in the order was that the Court of Appeals rejected that. He's talking about a student.
It's unclear. I mean, it's
Well, in the first appeal,
correct.
what was the position of how the labor should be?
The first appeal, frankly, the order of the district court, it delineated between direct and indirect expenses because these are unique free-flowing gas wells. And so Judge Kreitz delineated between direct and indirect expenses. This court came back and said that is not the accurate way to assess these.
To include more of these actual expenses.
Correct. And so in our brief on remand, we addressed those issues and specifically included the four expenses that this court asked us to address. Two of those were resolved by concession of the parties. The other two were not. And so we addressed those and how they should be applied, and not to beat a dead horse, but in the reading of this, it seems clear that the Honorable Judge Kreitz read between the lines of what he thought this court was ordering or how they were positioned on this matter. And I think that that's sufficiently tainted this to where it's not based on the facts. I mean,
And your contention is it should be volume,
it should be volume, yeah,
labor.
for labor and for maintenance. And the basis, if I could go into that briefly, the basis, so for labor, or I'll start with repairs and maintenance. I use the example of a vehicle. We all know that if a vehicle, you and I have the same vehicle, one has 200,000 miles, one has 10,000. Your vehicle, if it has 200,000, is probably worth less than mine. It's implicitly baked into the equation when it comes to, purchasing equipment. It's the same thing here. Without these other leases that produce the vast majority of the total volume, this compressor would not be run as hard or as often, and it would be able to have less.
And didn't opposing counsel, didn't they pretty much rebut that by showing evidence that there wasn't a difference based on a repair rate based on output there? I don't remember if it was output, but I know there was a chart of some sort that showed that in fact that was not the case, that the compressor, once the compressor is turned on and operating, it's a constant, how much to what area is not going to impact the repair and maintenance costs.
Correct. That was their position. That was not something that I believe was fully established in the district court in the original trial. And so I think that that's something that frankly
asked to rebut that when they brought that forward.
Well, I feel like in our brief, we addressed that. It's the same as, again, going back to the vehicle, you street race, Your Honor. I take my kids to school. One of those vehicles, we might have the same mileage on our vehicle. One of those is working harder on the engine, more likely for repair. So even if you take out the idea that time in and of itself that it's running, if it's running harder, when one vehicle is being pressed to its limits, the other is not, odds are there's going to be more repairs and maintenance. So without the MCF produced by the other leases, without that, the repairs and maintenance would be significantly less.
And okay. I would like you, because you're running out of time now, to address one key point, and that is in the opposing brief. It takes the position that even if we calculate things exactly like you are recommending that they be calculated, given the two items that were stipulated, baseline costs that were stipulated to, this is still a money loser.
Correct. And so the issue with that, with all due respect to Mr. Brock, in his calculation of the expenses, and I believe it's on page 11 of his brief, he has listed general liability as $1,338.70. If we look at the original order from this court, or from the district court after the initial trial, this was filed August 15th of 22. The district court, for the agreed it's on page 5, for the agreed 5-year time frame, the total of these expenses being general liability and license expenses is $228. So that's what we based ours off of. That issue was not addressed or appealed. The $228. I'm not sure where the $1,338 came from.
Might be in the first appeal, actually. I'll double check. Not right now while you stand here, but
Sure.
we'll double check.
So we based ours off of Judge Kreitz's original ruling that the expense was $228. If you factor that in with all of the other expenses as he has listed, the English lease would in fact still be operating in paying quantities.
Can I ask you one quick question? The standard for determining the paying quantities is supposed to be based on what's your actual costs, right?
Correct.
Whose responsibility is it to determine the actual costs? The leasee or the leaseor? The oil company or the tenant?
Normally, Your Honor, I would say the company that's actively utilizing the well or the well.
So is there a way that you could figure out the actual costs of maintaining these wells?
Because these are
operating the well?
Because these are such unique wells, there's no other wells to my knowledge like this in the state of Kansas. The standard, if we're trying to put the free flowing gas wells into the box of an oil well and apply that law, it doesn't fit. And so the factors that should be included or considered don't necessarily apply. And so that's why we're proposing, and I understand that this effectively, we're asking the court to create new case law that a well of this nature would have its own applicable calculation of expenses. And so we would offer it. It would be based off the MCF, which I believe is the most accurate, which, if I may, and I know I'm running out of time.
Yeah, you're out of time, but we've asked you some questions.
I appreciate it. Thank you, Your Honor.
Sure.
I find it interesting that the appellee in all motions and throughout all of this, the appellee has referenced that it could be per well or per lease. There doesn't seem to be a clear distinction of why one would be and when the other wouldn't. Simply, if you apply either of those, it no longer operates in paying quantities. The per MCF, and we're not asking for a blanket per MCF for everything. We're asking for it where it makes sense. And so labor cost, repairs and maintenance, and chemicals. They conceded on chemicals because without those chemicals, the same logic applies. And so we're asking the court to find that these are unique wells in their own right and to apply the per MCF basis to them.
Okay. Thank you. You'll still have your 5 minutes in rebuttal.
Thank you.
Afternoon.
This has been a long fight for what ends up being not a lot of money in the long run, although some pretty important property rights for Miss English.
Absolutely, Your Honor. And that's the real fight on our side is our client wants to have her property back. You know, when this case came up the first,
I have to talk a little
I'm
louder. I don't know. We
Yeah.
still have that fan behind me.
if I phase out, let me know
Okay.
because naturally I'm soft spoken. But when this case came up the first time, it was a really interesting case in that there were a lot of legal issues involved. And the court heard that case and they basically made a finding as to what expenses needed to be included in the paying quantities analysis. You know, and that to me is an interesting issue because it's a legal issue. And so the court has a lot of analysis to do. And but this time that we've come up, it's purely a factual issue. Was there substantial competent evidence to support the trial court's determination as to the amount of the costs that the court had asked them to include? And we would answer resoundingly that there is. With regard to the contract labor, we have in the record expenses from all the years that that the appellant operated these leases. And we also have the production month by month during that entire period. And so just to give you an example, in 2019, this group of leases produced 84,698 MCF of gas. In 2017, it produced a little over 75% more gas volume, 110,861 MCS of gas. But when you compare, for example, the contract labor expense, they're identical between both of those years. Even though the volume increased by 75%, contract labor numbers on those two are identical. The
The
reason,
idea being is you have fixed labor costs. It doesn't matter what volume you're talking about.
Yeah.
You have fixed labor costs.
and in this particular case, the real issue was, in a typical case, it's not hard to figure out how much time they spent. In this case, with a gas lease, the majority of the labor is spent at the compressor station, not at the individual leases. And the testimony at the trial court was that 90% of this labor is spent at the compressor station. That labor benefits all the leases equally. And so that's why it didn't wildly fluctuated. When we examined that witness further, how much time do you spend on this lease versus your best lease, and so forth. He argued that it was a difference in 90 minutes per year total time from his best lease to this lease. So the argument about why additional labor might be required doesn't align with the evidence. The evidence is that additional labor wasn't invested in those leases. And that is substantial competent evidence, that testimony, and then the clear records of the expenses and the production. The same is true on the chemical costs. Even though the volume of gas dropped by 75%, chemical costs went from $12,450 in 2017 to $14,625. Even though the volume went up, costs went down. With repairs and maintenance, again, 2017, $9,045. Production went down by 75%, but the costs are $16,321, almost double, which is reflective of exactly what the Court of Appeals said the first time, that even a new car can break down. To some degree, things break down when they break down, and the cost is just part of doing business. It isn't reflective of the gas produced. Service records are based on the number of hours a compressor operates, not on the volume of MCFs that pass through it. And so, again, the evidence in the docket says.
So help me understand this. So the least amount they are able to attribute to costs to the lease by saying we only spend 90 minutes there, so only that amount of labor costs. And the volume is very, very low to that lease. The less they can make that, the easier it is for them to show that this is still in the positive. Because as soon as it goes to the negative, they have to automatically relinquish the lease.
Yeah.
Right? I mean, am I getting that right?
So you're right in concept, but I think he didn't know the direction we were going when we were asking about the differences and the time spent, because that he should have testified that, oh, we spend a lot more time at that lease.
Because that would seem to make
Right.
the 300,000 mile car analogy.
That's right.
They need more time on those, but the testimony was that they need less time. So and in fact, they purposefully go to the bigger customers first to do anything that needs to be done. So I guess I'm just trying to figure out in my own head, how could a small leasee, it would be difficult to ever overcome the amount, to get into a negative, because
I didn't hear what you said with that last.
it would be hard for a small leasee, if you're just looking at how the time and volume on a per lease basis, you'd never have it.
Yeah. So,
And
the reality is that some of these leases are some of these leases are profitable.
Right.
Some aren't.
right.
What the operator has done in this instance is they have packaged unprofitable leases with profitable leases. That's why they want to apply an MCF basis, because that tells us if their entire operation as a whole is profitable, not whether each lease is profitable.
And and maybe I should ask your opposing counsel this, why would an oil company why would they want to keep this lease if it's really not producing anything worthwhile for them?
So a few reasons. The first is, as soon as this lease is found to be terminated, they have to plug the wells. Plug the 4 wells that would be on
Get into that.
property.
Okay.
That can be a substantial cost, especially with an older well. So typically you're trying to avoid the plugging cost. You also lose the potential drillable acreage on that property, depending on where
You
it's.
mean to drill new wells
Drill new wells.
based on your
Correct.
rights?
Yeah.
Okay.
I don't have this one in front of me on a map, but if it's situated in the middle of a field, it can create logistics problems
For the other wells.
for the other wells.
Okay.
So why they would keep it in this one, I don't know for sure. Plugging is it's always a big one. You don't want to lose a lease because then you have to plug the wells.
In the meantime, Miss English's property rights are restricted by the fact that there's an existing lease
Yeah.
on the property.
Yeah, I mean, this, I mean, the case started because our client, she's about 80 years old. She lost heat to her home because she was supposed to be getting free gas. That's how the case started.
Right.
We were trying to restore her gas service to her house. And so getting the lease off her property is the biggest thing. But also at that time, when she wasn't served by commercial gas, we were trying to get the heating source back for her home.
Thank you. I need to try to
Can
understand.
we address the general liability insurance, which is, it's kind of it's possibly not gonna be able to answer it. So why you are attributing 1338.69? They say that the district judge attributed 200. I pulled up the prior case that said the district court didn't accept an interest calculation and found it should be prorated based on leases. It's okay if you don't.
So when he said that, I went back really quick and tried to look while I was sitting there.
What, you mean how the discrepancy? came
Yeah,
out?
how the discrepancy came out. And honestly, I haven't found.
All right,
it yet.
we can figure it out
I
later.
don't know. Yeah, I don't know the answer to that. The one thing I would note, there was a question earlier about this being heard on the record, and so a potential that the review could be de novo or you could figure it out. The thing that I would point out is even though the remand was only briefed, this was a case that was tried to the court. This isn't a case that's presented on a written record of stipulated facts or something. This same trial judge heard the evidence, weighed.
On remand? I mean,
On
it was a
remand.
trial on remand?
No,
No.
I'm sorry. I didn't mean to confuse it. I'm just saying that I understand there's a body of case law that if you present a case that's on a written record, it's a de novo review versus on a record before the trial judge. I haven't specifically looked at the cases to see if there's, how a remand can affect it. But I guess in my view, this isn't a case submitted totally on a written record because there was a trial. We did advocate even in the briefs that this witness's testimony supported each decision.
Because even though you're only looking at these issues, you have to refer back to what the testimony was. Okay.
Absolutely.
And it
Okay,
was the
that
same
makes
judge
sense.
throughout.
And the same judge throughout. And so he still was weighing the credibility of those witnesses at different periods of time, clearly. But I guess that would be my position as to why there is substantial competent evidence standard as opposed to a de novo standard.
Do you do a lot of oil and gas law or?
Yeah, that's
Yeah.
probably about 95%.
So what, I mean, this can't be the only time this has ever come up. I think there's a Claiborne case that kind of talks around this a little bit, but generally, how are these leases measured as far as expenses?
So on a general basis.
I'll
Yeah.
allow you to respond to that.
On a general basis, an operator is not allowed to operate multiple leases and commingle production into one. You can't do that.
That's why this is unique.
You can't do that unless you pool or unitized. Here, they've just done that and no one has really challenged that because there are no facilities setting on, like, for example, if they tried to put the compressor station on our client's property, we would have said, no, you don't have the right to bring other people's gas on our property. Move it. Here, that factual scenario allowed them to commingle production when typically that wouldn't be allowed.
Okay,
So
that makes more sense.
even though this case, the first time up, presented the legal issues were well established in terms of which ones to apply, the how was not well established. And I'm not enough of an academic to file a motion, but that opinion deserved to be published for what it's worth. I'm serious. Like it addresses the allocation of expenses in a natural gas lease in a way that isn't done in Kansas courts or in others. And I'm not saying done differently. I'm just saying those facts hadn't come before the appellate court before. And so, I believe that from that basis, that's a reason why it should be published because it was unique. And more importantly, you guys got the right answer too. That's,
So you can always make a motion to have an unpublished.
I know. I just, like I say, I'm not,
Okay,
but yeah, that's the reason that we don't typically see that. And, with the natural gas leases, it's almost the opposite. The argument has been, these are unique, they're free flowing. The majority of the natural gas leases are free flowing.
right.
We also have a unique category of wells called coal bed methane wells that require artificial lift. Those are actually the unique ones in the spectrum of, national scale or even the statewide scale. So this issue that's before you, it's the first time that it's gotten here, but as the Hugoton field is being played out and diminishing, it won't be the last time that you've heard about it. This is the first of several, I would say, that will come up. So
Okay.
I think I've made my pitch. Hopefully it's been received. If there's any other questions, I'll take those. Otherwise, I'll
Well, thank you very much.
thank you all very much.
And Mr. Vaughn, what's the standard practice? This is unique.
Yes,
You agree, they agree, this is a unique situation.
correct.
In a typical situation, how would these expenses be allocated?
So typically, and I don't have the luxury of being quite as well versed in oil and gas as Mr. Brock.
He's not that old. Don't.
Typically my understanding is they do not commingle, as he stated. This case, because they are required to be commingled, it forces this issue before the court. As he stated, this.
So when they're not commingled, does that mean you are from the very beginning tracking the expenses related to each?
It's much easier. So if my wife and we have joint accounts. If we had separate, it'd be really easy to say, well, you spent this, I spent this. But when it's joint, it mixes
Muddies.
things up, it muddies it. And so that's what we're trying to get at here is how do we go about figuring the most fair, just, and equitable means for determining cost allocation?
I think the point though about the labor not changing with the volume changes is interesting.
Yes.
The labor cost, because does appear just to be a fixed cost over time.
Okay.
That makes.
There's no reflection on your argument.
So, and I will say that also the decision on how to package the leases also appears to be, beneficial and strategic to the gas company, right? It's like, packaging A-bonds with
Yes.
low tier bond. What was that movie?
Yeah.
And so by doing it that way and then pushing for a per volume, you can make sure that these low producing ones are never, ever go away. And is that the intent of a lease that says when it doesn't pay in paying quantities, it goes away? Isn't the intent to make it so it never goes away?
No, so that's a great question. I guess first to address the contract labor. So the company has one salaried employee, Mr. Ellis, and our client, NNB, they're very business savvy. They would not pay Mr. Ellis for the work he does if this was just the English lease. So it's
That's like pure speculation, though. I mean, you could have made it so it was just the English lease, and then you would see that it was not profitable and it would go
true.
away.
Then at that point in time, yeah, it would not. But a prudent business owner, I believe, has an interest in paying appropriately, but not overpaying. And so if we have one lease that produces less or just over 0.5% of the total MCF, it wouldn't make sense to pay him what they do. Frankly, that's probably something that the owner could do themselves. So I believe that the labor cost is baked in and directly correlated to the MCF basis, even though it does not change if they were to let's say their production doubled again, whether it be adding one new lease that totally doubles their production. At that point in time, they might need to hire another employee. But the issue is you're only adding one lease. So now you have several leases well, I'll go back here. So the English lease, if we apply the law as requested by opposing counsel, no, they wouldn't be able to be included in this because they would be precluded, as Your Honor addressed, because they don't produce enough. And so based on success of other leases, solely out of their control, they are asking the court to not allow them to be a part of this when, if they were on their own, they would be profitable. And so they're trying to saddle more successful leases, their costs, the increased costs that are associated with them.
You think that if the English lease was on its own, it would be profitable because you'd be able to show no labor for managing a compressor for it?
Yes, and I'm going to paraphrase, but I believe at trial, Mr. Burris stated that if the English lease operated on its own, that it could be operated using I think he said like an air bubble, like a gas compressor or a garage compressor.
That never needs repair?
The repair, the maintenance, it would need it, but we're talking about significantly different equipment. We're talking about significantly different needs for labor.
But we have no proof of any of that.
And so that goes back to the issue of, I believe that the district court, when we had the original trial, they were applying incorrect case law. They likened it to indirect versus direct expenses. And as this court acknowledged, and I believe correctly so, that is not the accurate method of applying
But it's
expenses.
your company's responsibility to demonstrate direct costs,
Correct.
which you don't have.
Well, we provided the labor costs, and we've provided the repair and maintenance costs. The other two expenses are not at issue any longer. We've prepared those costs, but how we allocate those, because there is no case law that says how they have to be allocated, because they're pooled together out of necessity, we're saying that the most fair allocation is per MCF, not per lease. And just to go back to the point of per lease versus per well, I find it interesting that opposing counsel regularly referred to it could be per lease or it could be per well. It doesn't appear that they were necessarily married to any one of those ideas. And I think that that's telling in that there's very little correlation between the two and
Who
the actual
decides how
production.
many leases go in how many wells go in a lease?
I think it's based. I don't know the answer to
So
that.
in order to say, well, it definitely should be per well, you'd have to have some thought like, well, one lease equals 2 wells, so et cetera, et cetera. But if the company is just sort of packaging them up to be most profitable,
Mhm.
then the per lease and per well means little to the company either.
Sure. So if you have one well let's say you have one lease that they add and it has one well that produces a large number of gas. If they add another well to that lease, you still have the same lease, but now you've doubled your wells. Production arguably is still the same, even though you have more wells now. And so I think that's the issue. There is no correlation between that. You can add expenses, but the per MCF, I think that dictates, because a prudent business owner is going to maximize their profits.
And one last question, and we're out of time, but it goes back to the same question I asked opposing counsel. So what is the downside to the company of releasing this lease?
Well, I think Mr. Brock accurately stated that
Such a minuscule part of the whole thing. What's the downside?
the downside is that they would be giving up profit. Our client has portioned the cost per MCF, and on that basis,
They're making a profit.
making a profit. However much, they're making a profit, and so they want to continue making that profit. But if the well were to be no longer operating in paying quantities, then yes, they would have to cap it. I couldn't speak to expenses on that. That's kind of above my pay grade. So, the last two things I wanted to address.
Very quickly.
Yes, it was on page 5 of, the judges or of Judge Kreitz's original decision, August 15th of 22. The bottom paragraph is when he said, for the agreed 5-year time frame, the total of these expenses, these being general liability insurance and license expenses, is $228 is what it came out to.
Okay.
Finally, I just wanted to brief the court on the issue of attorney fees. If for some reason this court finds that the district court adhered to the mandate of this court and that it was based on substantial competent evidence, we would ask that the court not order attorney fees because our client has operated in good faith. So the standard is reasonable diligence, good faith, prudent management, and no intent to abandon the lease. Prudent management, reasonable diligence, and good faith, based on our client's own perception of how they decided it was most fair to allocate expenses, they determined that this is still an operating and paying quantities, this lease. And so they've used reasonable diligence.
Yeah, they had a good faith argument.
They did, and there's no intent to abandon the lease because quite frankly, we wouldn't be here. They've spent far more money being at this point than they would capping the wells. They want to essentially have this court, we're requesting that this court order that moving forward, that unique wells such as these be applied for a per MCF basis on the issues of repairs and maintenance and labor.
Thank you very much.
Thank you.
Thank you both. I appreciate your arguments today. I'm sorry if there was a confusion about.
Your Honor, Your Honors, I apologize for that this morning. That will not happen.
Thanks for making it down.
Yep.
Thank you.
It was a really good argument.
And thank you very much, Mr. Brock, for
Thank you.
sticking around.
That was nice of you.